Hello, everyone. Welcome to another edition of Court Chatter Live, and this will be a great one. So I'm Kathy Russell from courtchatter.com, and I will have my guest on here who's becoming a regular co-host with me, Attorney Phil Holloway. We had just got through with closing arguments in the Justin Ross Harris trial, the hot car death trial of .com, and I will have my guest on here who's becoming a regular co-host with me. Let me get rid of this. Sorry about that. Thought I had that taken care of. Okay, so you guys all know I don't need to go over the details of what this case is about. If you're not, you can Google it. Okay, so we are going to talk about today, let me just tell you how they finished up. All the closing arguments are done. The jury has been charged, which means they have been read the jury instructions, and then it was end of day. So the judge sent them home for the day, and they'll come back tomorrow morning and begin their deliberations. So that's where we are. Not quite on verdict watch yet, but we're just about there. And I am going to go ahead and bring Phil in right now. Hi, Phil.
Hey, good afternoon, everyone.
How are you?
We're doing great now that we don't have to listen to the jury charging going on anymore.
I think that's your favorite part, right?
Oh, I bolt as soon as that starts. I tune out. I've heard it all before. I've got the entire pattern jury instructions. If I want to read them, I can read them for myself.
Okay, so right now I'm showing you a little fuzzy and stuff when I look over on the stream. I don't know if that'll work itself out or not. We said last time Phil's in his office and sometimes his wireless there isn't the greatest connection, but hopefully that'll work out. And why don't you guys go ahead and tell me in the chat room if the connection is fine. And Goat Girl's first question to you, Phil, is where is your cat?
My cat is at home, and I'm at my office. And, my cat is 19 years old, so I'm assuming that he's still there. That could always change.
Oh, don't say that. No, your cat's a big hit with the trial watchers, so they're big animal lovers. Okay, so let's get started here. I'll put me back up for a minute. All right, so we had ADA Chuck Boring give the prosecution closing argument and the rebuttal. The state got to go first and last. It's their burden of proof. But each side received the same amount of time. Defense attorney Maddox Kilgore gave the defense closing argument. So we first heard from Chuck Boring. And I think what I'm going to do is just sort of hit some points that Boring brought up during his first closing and talk a little bit about it. I liked when he said, if Cooper's car seat was visible from all angles in that car, then he is guilty. So, Phil, what I have to ask you about that is that's playing to when the jurors went out and looked at that car, right, with the car seat in it?
Not only that, Kathy, but the photographs as well. And I think one of the photographs that the prosecutor used over and over again during his closing arguments was essentially what someone would see as if they were approaching the driver's door like Mr. Harris did at lunch. And, you know, there's multiple pictures. The jury's going to have them all. But they picked that particular one, and it's similar to one that I've put out on my Twitter feed, which is some of the most compelling evidence, in my estimation, is the close proximity of that car seat to the right shoulder of the driver. And if you have a child's head resting on top of the child's seat, that makes it even more likely, at least in the state's estimation, according to their argument, to be in someone's peripheral vision. So they're using the limited time they have to talk about the strongest evidence they have, and that goes for the defense as well.
You know, that was a source of contention with the defense, what I just brought up about the jury going out and visiting that, going out and looking at the car. And you and I have talked about it. We don't need to go into detail about it again. But their big argument was that was, you know, not the same conditions, not the same light reflecting off the tinted windows. And the jurors got to go out there and basically do their own experiment. Now, legally speaking, that wasn't it, because you have explained to us the SUV is a piece of evidence, and just like any other piece of evidence, they get to look at it. If it was small enough, they'd have it in their jury room, and they'd get to hold it and manipulate it however they wanted. So that's why they got to go out and see the SUV. But I do see the defense argument on that those conditions are not the same. And while you might have been able to easily look into the car that day, it was different on the day that Cooper died. So
what I was listening for was the words from Mr. Kilgore. I was listening for the words, nobody has shown you any evidence of where my client's eyes were focused as he walked into the car. He didn't use those exact words. He did make the point over and over again that the jurors were specifically looking for the car seat. So obviously they saw it. But nobody knows exactly what, if anything, Mr. Harris saw. I think that the overall point that the prosecutor makes is that it doesn't matter where you're looking. There's no way that you could not see it. So, that's sort of the whole issue is it's obvious that it could be seen. And the question really is, was it in fact seen? And I think the prosecutor keeps coming back to there's no way that it couldn't have been seen.
Right. And, that's hard for all of us, I think, that have now seen the inside of that. When you think SUV, when this first started coming out, all the information, I think like, suburban SUV. And then when you realize it's not, it's just one of these hybrid cars. It's just, it's the same size inside as a car, as far as I'm concerned. It's a 5,000.
When I first heard about it, I thought it was in my vehicles, in my vehicle I had at the time and the one I have now, the child seats, I only have one now, it's a booster, but at the time Cooper died, I had a very similar car seat, but it was directly behind the passenger seat. It was not situated in the middle, right between the two. So when I first saw that in this trial, that was my, oh wow. I didn't realize it was that close.
I don't remember anybody talking about why the car seat was in the middle that way, because I'm not so sure that's the safest way to put a rear facing.
I think it depends on the car and where they have the latches where you basically attach the base. Okay. Some cars have latching points, and it depends on where they are. But I didn't realize until this trial started that it was literally almost by his shoulder. And I think that had a lot to do with why the prosecutors didn't buy that kind of story.
All right. Okay, so it was powerful for me when Boring started his argument, and I'm just going to read what he said. He talked about him pulling into the parking lot of Home Depot, pulling past the parking spot he wanted, having to back up, which, we all kind of know probably what you do when you back up, and then pull forward into that spot and then sit there for 30 seconds. And he sat there for 30 seconds and Cooper's not making a sound. Now, Boring didn't say this part, but this is what I'm thinking. And Cooper's not making a sound for 30 seconds. And he says he then got out, closed the door on that little boy's life so he could pursue his other life. I thought that was pretty powerful, and that's how he started his closing. Yeah,
and if you notice, they go first, and then the defense goes, and then they go last. And so in his first part of his closing, he's a little bit more subdued. He makes some certain points, things that he wants the jury to be thinking about while the defense is talking. And he gets to, and today they got the entire lunch break to fine tune their argument. For the last time, you saw a much more animated, a much more aggressive, the gloves are now off kind of prosecutor that went through in more detail why, in their opinion, this had to be intentional. It had to be malicious. And there's no way that his story could conceivably make any sense whatsoever. And if his story is not true, the story that he told police on the scene and at the police department, if that's not true, then this is a malice murder. And I think that was the point they were trying to make. I'm not necessarily taking their side. I think the defense made some very, very good points as well. And I think that the way the defense ended its presentation with the father and son playing around on the guitar, having a fun moment together was if there was a way to make Ross Harris personable and seem likable, then that was it. And when I saw that video, I kind of felt like he was more of like a dad, a real person. And so I thought that was a really good job by the defense at humanizing a client who has some very, very obvious flaws in their personality.
Well, yeah, so you jumped ahead of me because I was going to get to the defense. We're still on the state there, Phil. Okay, but, actually, so what I did want to stop and talk about, since obviously this is what, for me, this is what the whole case is malice. And what the judge explained to the jurors that I tweeted out, because I tweeted out exactly what she said, at least in that part. And she said, malice murder is the unlawful intention to kill without justification, excuse, or mitigation. So right there, that's what this whole case is about for me, is intention and intentional. Do you want to give us a better, maybe a broader understanding of malice murder? Or at least what do you think the lay people are going to do in that jury room with that whole definition of malice?
If you'll ask me another question, I can look up the pattern jury instruction real quick and tell you exactly what it says.
Okay. Here we go. Goats Girl wants to know, why did the judge refuse the lesser included charges? But I didn't. What do you know about that?
Well, judges have to decide when a defense, this usually comes from the defense, occasionally prosecutors will do it, but when a defendant requests a lesser included charge, the judge has to be satisfied that there is evidence that's been admitted in the case that would fit the definition of offense. And the judge's ruling in this case was that there was no evidence to support anything that would be a lesser included, say, for example, a manslaughter. So going back to your other question, I found Georgia's instruction on malice murder defined, and I'll try to be as brief as I can. A person commits murder when that person unlawfully and with malice aforethought, either expressed or implied, causes the death of a human being. It says to constitute murder, the homicide must have been committed with malice. Legal malice is not necessarily ill will or hatred, but is the unlawful intention to kill without justification. In other words, not in self-defense, without excuse, and without mitigation. Okay, so excuse and mitigation would be things that go to the heat of passion, as in a manslaughter, or be things that would show some lesser degree of intent. It says if a killing is done with malice, short a time the malicious intent may have existed, such killing constitutes murder. Mr. Boring said that, and I didn't know this about Chuck, he's a friend of mine, but he told us today that he doesn't know how to snap his fingers. But the story, the way it's typically explained in trials is you tell a jury, malice does not mean premeditation and deliberation. Sometimes it is, but it can be formed in an instant. Okay, so it doesn't necessarily have to be something that's thought out for a long period of time.
Let me stop you right there, because that bothers me a little, because I think the prosecution's theory is kind of all over the place, because they do this whole thing about how he wanted to be child-free and he wanted to pursue his other life and he wanted all that. Then they have to back it up and say, oh, but he just decided right then when he left Chick-fil-A. So it's like, which is it? And the point that I liked about what Matt Kilgore brought up was that Leanna Harris, now Taylor, had been a suspect throughout this entire investigation. If she's a suspect, that means she was in collusion with her husband to kill their baby. And if that's the case, then their theory about why Ross wants to kill Cooper doesn't hold any water, because they say he wants to kill Cooper so he doesn't have to be married anymore and doesn't have to have any of those problems associated with that and having a child, and he can go on to his other life that he wants. But then Leanna would have nothing to do with that. So, which is it? And I thought that was a good point of the defense closing.
Well, that is an interesting argument, and if you follow the case very, very closely, and as you noted previously, other than this trial, which is 6 hours away from me, I've been in the courtroom for almost everything they've had, and the prosecutor they've kept the evidence very close to the vest. They've kept their overall theory of how they're going to prove malice, very close to the vest. And it came out during the trial that Leanna was initially a suspect, but it didn't take them very long to figure out that, you know, she wasn't in on it. And Boring, to his credit, I mean that in the sense of being a skilled litigator, as a colleague, I think was a really good way of doing this. In the very end, his big reveal was something. Yes, he went and he looked at this child-free site, and yes, he looked at this vet video, and yes, he had all these extracurricular activities going on, and he did live a double life. But it wasn't until that whisper popped up at the Chick-fil-A that some light bulb flashed, and it was at that moment he decided, you know what, I'm going to go ahead and I'm going to get my escape right now. So they didn't tell anybody exactly what their theory of malice was until nobody else had a chance to talk, because Boring got the last word. And so he was able to tie that all together and say this was something that he was sort of thinking about, but he decided to act on it at the Chick-fil-A. Right,
and that is how he tied it up. Let's go back to Boring's closings. The theme really on the state was what we've been talking about, that Harris had this other life where he was sexting and meeting in person and being physically intimate with other women, and that the whole being married and having a kid thing isn't working with this other double life of his, and he needed out. And so that was their whole theme of their closing, of Boring's closing. Also that that all the witnesses that came in and talked about Ross, turns out they didn't really know Ross. So all the witnesses that came in for, this is what Boring was saying, all the witnesses that came in for the defense that talked about how Ross Harris loved Cooper more than anything and that he adored that little boy. Well, guess what, jurors? None of those people that were the very closest to Ross, that knew him the very best, knew he had all of this going on in his online life and all of this going on with other women and with minor girls. They had no clue about it. So yeah, they may think that he loves Cooper and adores Cooper, but if they didn't know about this whole part of his life, then it's very possible they didn't know he was capable of deciding to do this. And this has been an argument also in our chat room, that this was a non-violent murder. And so I know that, you know, all murder and the way Cooper died was horrible, but as far as not having to physically put your hands on that baby and kill that baby, I think that is also goes to somebody who decided maybe at the last minute to walk away from it all.
Well, you know, there's certainly no more of a torturous way to die that I can think of, other than maybe being burned at the stake, and this is pretty close. You know, and there's certainly no more torturous way to kill someone if you're going to do it on purpose. Now, if they, and this is speculation on my part, I honestly don't know, but when they decided that this was not a death penalty case, that sent sort of a hint that maybe they weren't sure that they could get 12 people to unanimously decide that this was malicious. In death penalty cases, guilt or innocence is on murder is usually a foregone conclusion, and the trial is about the penalty, whether or not the person gets the death penalty or not. This not being a death penalty case, and when you include count 3 in there, which is predicated on something less than malice, it's probably, if I had to guess, it would be a safety net for the prosecution in the event that a jury, just like the people in the chat room and some people watching this now, just can't quite get their head wrapped around, you know, I can't believe that a father would kill a son this way. And I think Boring even used similar words to that in his closing. He's like, you know, we just can't understand why this happens, but we know parents and adults do these things to children. But I think that I think that there's just a common sense understanding that it might be difficult to prove malice beyond a reasonable doubt to 12 people. We certainly can debate it because none of us, except Ross Harris, know exactly what was in his head.
Right, exactly. All right, so we talked a little bit about the prosecution. The defense's theme of their closing argument was, Mr. Harris is responsible for Cooper's death, but this was nothing more than an accident. That he forgot, that he did forget in just those few short minutes, and that the state couldn't bring you one person to tell you that Ross did not love Cooper and adore Cooper, and so what if, maybe he was being rotten to his wife, but nobody could say anything that he didn't adore that child. That was basically, and their theme was, law enforcement rushed to judgment, and they immediately on the scene, and they built their case around that, and they talked about Detective Stoddard a lot. So those were sort of the two themes that Maddox Kilgore went over. So why don't you give me your thoughts?
Well, that's been their theme all along, and it's really the best theme that they have going for them. And there's a lot of information out there that supports that theory. Boring did a decent job, I think, a pretty good job actually, of kind of neutralizing that in his final summation, but it doesn't change the fact that lots of things were said in search warrants to magistrates early on that were inaccurate. I'm not saying they were perjurious or that they were lies, because for it to be perjury or for it to be a lie, you'd have to actually know that it's not true. So I think the point that Boring was trying to make is that things evolve over time, and what it might look like in week number 1 is not what it looks like 6 months later after we were able to do more forensics. But from the very beginning, the defense has been very vocal by saying, Stoddard immediately jumped to a conclusion, and he built his case to support that conclusion. And it's a valid argument, because a good investigator will objectively follow the evidence to the truth wherever it may lead. And if it leads to innocence, so be it. If it leads to guilt, then it leads to guilt. So what they've done is they've said, look, this is a brand new detective. This is his first murder case. He decided that subjectively Ross Harris wasn't acting right, and therefore it must be a crime. And they made another very good point. That guy's boss, then Lieutenant Farrell, testified that, hey, a child's dead, and the father caused it, therefore it's a crime. Well, Kilgore, I think it was, when he said it, I mean, all of us want to jump and clap, because I hear this a lot of times from, and not because I'm taking sides, but because I hear this from law enforcement officers. They sometimes don't know what the law is. And just because somebody dies, and just because it's a child or your child, doesn't mean it's a crime. And so for Farrell, who is the boss, to basically take the position that, all right, we have a dead child, somebody's going to jail, it has to be a crime. That's not how the law works. There is something known as accident. The judge told the jury about the law on accident, and Maddox Kilgore hammered that during close. Just because there's a death doesn't mean it's a crime. And I personally have had cases where one person dies and one person is alive. When it's all over, the police show up, they immediately drag the person who's alive off to the jail, and they say, somebody's dead, somebody's going to jail. And it didn't work out so well for the cops in that situation. And there is merit to the idea that police get tunnel vision. And if the defense can prove that that's what happened in this case, they very well could get a not guilty on everything except for the sexting. If the jury believes that, they could get a not guilty.
Okay, so back to Farrell's testimony. That's exactly right. I think he was just being, stubborn to be stubborn, that he was not going to give the defense what they wanted. And so he was insistent that it was a crime, it was a crime, it was a crime. We saw a lot of combative witnesses on both sides during this trial, which, you know, that's pretty much par for the course. That's what we do see. But sometimes law enforcement can testify very neutral and just give the facts. I see that in some trials. And then other times I see them being very defensive. And so that isn't unusual to see that because, you know, they're being questioned on their jobs and their practice, and, you know, they're right. That's what they think. So I think it comes across better to a juror if you just state the facts and keep your emotion out of it when you're a professional on the stand. When they have the other witnesses, that's different.
I can tell you, when I was a prosecutor, I would cringe when I had police witnesses that testified that way, because you're exactly right. They come across as being, well, let's just say too much of an advocate for one side and not someone who's a objective searcher for the truth. And there's nothing at all wrong with a police officer believing in their case. There's nothing wrong with a police officer standing by their work product. There's nothing wrong with a police officer saying, I'm proud of a job well done. But when there are mistakes that are made, there's not one person, certainly no police officer, who has never made a mistake. You saw the prosecution in this case admit some mistakes. They admitted some things that they did in trial were not adequate, and they wanted to go back and fix it. So they owned it. And so accepting responsibility for mistakes makes you more credible. And so how does the real question is, how does the jury perceive Detective Stoddard and some of these others? Do they perceive him as being a police officer who is proud of a job well done, and he's indignant that some sleazy defense lawyer has the nerve to question him? Or does he come across as someone who is a little bit slippery and you can't get him to admit that the sun is shining when it really is?
Right, exactly. Okay, and in Kilgore's closing argument, this is the defense, at the end, he played the video of Ross and Cooper, and Ross playing the guitar and then letting Cooper go out and play it. And it was just heartbreaking, heart-wrenching, first of all, to see Cooper alive like that. We've seen some videos during this trial. But their point of playing it was, this was the kind of father he was, because it showed him laughing, having a good time with Cooper, letting him play his guitar. It showed a cute relationship between the two. I thought that was powerful. And he also ended up on the screen with the words that now you all know what Cooper's mother has always known, / this was an accident. And that's how Kilgore ended. I did think that was a powerful ending to his closing argument.
It was. And Maddox Kilgore is a very, very good lawyer. All the lawyers in this case, I know every one of them. They're all great people, great, smart lawyers. It was a very strong way to finish. And I've never seen this before. And when I see Maddox, I'm going to have to tell him that, you know, look, I think this was brilliant. When his last words to the jury, we trust you.
Right.
I've never seen that before, and I may have to steal it someday and adopt it for my own. But I thought that was a nice touch. I mean, you know, that was from a trial practice perspective. I thought it was great. I also like the fact that he went through and, at least with respect to the murder and the cruelty charges, asked him to write 2 words in there, not guilty. I expected the prosecutor to end with that same verdict form and say, don't write 2 words, write 1 word every single place, because that would be justice for Cooper, and then maybe hold up a picture of Cooper or something like that. Hey.
Yeah, let's talk about how Chuck Boring ended his. He ended his final closing argument by saying this case is about justice, and it's about the little boy Cooper Harris. Today that boy would be 4 years old, but he's not. These aren't exact, by the way. These are just some words.
No, that's right.
He's not here with us because that defendant took him. That defendant took his life for his own selfish, obsessed reasons. And then he says, who's going to speak for Cooper? The evidence speaks for Cooper. It can't bring him back, but what can be done is justice, and you as the jury have the opportunity to do that justice. Very powerful to me. I agree with you. I said it at the time when I was watching it, that he should have had a huge picture of Cooper, while he was saying that. That should have been put up, and it wasn't, but I did think that was a very powerful ending to his closing argument.
I thought that myself at the time, but I also wondered why he might not do it. There's been so much, I don't know that the jury really needed or wanted to see another heartbreaking picture. I think they got it. I think when they saw the images of Cooper's deceased, lifeless body, and we actually saw some of that in a live feed that I don't know that anybody was aware that those images kind of came across the bottom of the screen. But listen, those pictures, and it was only brief, but it's seared into my brain, and I'm watching it on the live stream like you guys. So to the jury that's going to have these photographs in the jury room with them, it may be just something that Boring says, listen, I just don't need to do this. It is possible to overplay your hand. Well,
no, we've definitely seen overplayed hands in trials before, but I don't know. For me, the big picture of Cooper at the end while he was saying, the justice is in your hands for this little boy, that would have been powerful. Okay, let's get to some questions. Cindy wants to know, what happens if the jury is not unanimous on some of the charge, or unanimous on some of the charges but not on all? Now, it is possible that we've got 8 charges here. It's possible they're going to be all over the board on them. It's also possible they're going to hang on some of them. What happens when that happens?
Yeah, so I guess the answer is it depends. Yes, they can convict on some, they can get hung on others, and they can acquit on any or all. Let's just say, for the sake of this discussion, that the sexting charges are going to be guilty. I think the defense all but has conceded that point. So right there, you got 12 years worth of jail time. He's already been in jail over 2. He would get credit for that, but assuming that that's all that he's convicted of, he's got a decade in prison and another indictment behind this. So that raises some real for the prosecutors. If you get a hung jury on all the murders, or maybe a not guilty on one and hung on something else, and you have to declare a mistrial, do you retry this case? Do you retry a malice murder case? Because you'll have the same issues that you had. Can you get a fair trial in Cobb County? Now, everybody in Cobb County in Georgia who's interested in the case has watched the entire trial, including the things that the jury didn't get to see, such as the things that took place outside the jury's presence. So now you have some very real considerations about, do you retry the case? Do you spend the money? If so, where do you do it? And then why do you do it? Because and I don't know this for sure, but my very, very strong feeling and instinct is that there's a minor victim, and I know her name, but I won't say it, who is named in the indictment, and she's one of the ones that testified, but we didn't get to see or hear. Okay, there was also another one that was younger than her that actually did send, according to how the testimony has been described to us and what was said today in court, did send photographs to Mr. Harris of her private parts. Now, that constitutes a completed, instead of an attempted, he's charged a criminal attempt to, I'll just call it child pornography. Georgia's got a different name for it. But he's indicted for an attempt because he never actually got a photograph from the victim named in the indictment. He asked for one, he didn't get it. The jury heard from a young girl who did get a photograph, okay, who did give a photograph to Mr. Harris. So that is a completed act. That is probably part of the second indictment. And that's a 20-year plan.
That's not in this trial.
No, but the witness in this trial is probably one of the victims named in the second indictment, because Boring today talked about things that we learned about after an indictment. For example, we learned that he was receiving pornographic material from 15-year-old girls, and one of them testified in this trial, and I'm summarizing too. He talked about, you'll see the messages where he's teaching her essentially how to perform oral sex through his text messages.
Oh my gosh.
So what that was a description of is the completed offense of sexual exploitation of a child, and that is what he's indicted for in the second indictments. I wouldn't be surprised if that witness in this trial is not one of the named victims in indictment number 2.
Ah, interesting. Okay. Allie wants to know about, okay, can Harris be found guilty on all 3 murder charges? I thought it was 1 or none.
Nope, he can be indicted. He can be found guilty on every single count. Now, if he is found guilty, then there's a legal issue of what charges might merge or blend into another charge. I think that the felony murder charges would absorb the cruelty charges. In other words, cruelty would be absorbed into the greater offense of felony murder. So some of the offenses would merge, but a conviction on any murder carries a mandatory life sentence, and wouldn't surprise me if the judge doesn't make it life without parole. It also wouldn't surprise me if she doesn't make it life without parole plus 10 for the sexting, plus another 12 months for one of the misdemeanor counts of disseminating harmful information to a minor, and then another 12 months for count 8. So wouldn't be surprised if he's convicted of any murder and he gets life without parole plus 10 plus 2 more years.
Okay.
So,
Juice wants to know, does criminal negligence apply to count 4 or only count 5? So can it apply to the malice?
no, criminal negligence is an element of the offense of cruelty to a child in the second degree, which is the underlying felony that the count 3 felony murder is predicated on. So criminal negligence is what we call the mens rea, or the guilty mental state, that's required for counts 3 and 5.
Okay. For those who haven't seen it, Phil does live right there in the area where this all happened. And the other day he took the drive from Ross's work at the Home Depot Treehouse to where he pulled over at Acres Mill Square. And, you know, that's when Cook Cooper was taken out of the car and all that. He took the drive the other day, and we have that on our YouTube channel. And Fight has a question about that. And she just said, she wants to know, Phil, when you took that drive, do you believe that Ross could have easily seen the car seat?
The reason I took that drive, and I'm going to get to answering the question first, but I was actually running errands in that area. That's how close I am to where all this took place. In fact, I get my hair cut about 2 blocks away from where Ross Harris worked. So it was not out of my way, and it was actually on the way to my bank. I had to go make a deposit. So I said, hey, let me just check it out. And I'd been over there before to see it, but I used to live a quarter of a mile away, and I used to eat at that place all the time. I can't go there anymore because it just breaks my heart knowing that was where Cooper had his last meal. But nevertheless, I did, while I was there, decide to just, because it had come up recently in the trial, and I wanted to see how often in my driving I might have to glance to my right in order to navigate that route. And I don't know what lane Harris was in, left, right, center. I don't know if he was caught in any red lights. I don't know any of that stuff. But I do know the route that he took. So I just drove the route, and I wanted to see how many times I had to glance to my right. And I had to glance to my right several times. The first time I had to glance to my right was when I turned out of the treehouse location. And I also looked to the left, but as I turned my head to the right to make the turn. I had to go through a couple more lights. If the lights were green, you would want to look both ways to see if there's oncoming traffic. I had to make another right turn. And then he made a turn onto Acres Mill Road. That came up in the trial. It's not how I would go to the movie theater. Now, admittedly, you can get there that way, but it's not the closest and shortest route. And that was when he said to the police, I just kind of glanced to my right to change lanes, and that's when I saw his head. And that's when he whipped into his final stopping place. So I had to turn my head to the right. I had to glance several times. I have no idea what conditions Harris might have been driving under. I don't know if he was on the phone. I don't know if he was distracted, if he was texting, sexting. I don't know what he would have been doing. But I was just curious as to how many times I might have to glance to my right.
And I think
it was several.
I think this goes to maybe not if could he have seen, but did he? And that's what you just said.
Right.
We don't know what he was doing. We don't know where his mind was. Okay, Smudge Pudge has a comment. Phil Holloway makes a good point here. We've seen far more than the jury has seen. What with arguments and motions outside the jury's presence, we can actually argue more because we've heard stuff. And that's true. And that's what I always try and keep in mind at every trial, that we know more. We know more than this jury knows. We see all the arguments outside of their presence. We've read a lot of the documents and a lot of the motions, and we always know more than a jury's going to know. And for me, interviewing jury members after trials, that's a fact. I have shocked some jury members when I have given them information that I had. And I had the last one say to me, I wish I would have known that. And there are things they can't know. So we do have to keep that in mind, where I believe personally, we'll talk about at the end what our beliefs are, what's going to happen. But what I believe is going to happen in the jury room might not happen because they don't know everything I know.
Yeah. And as a lawyer, sometimes you just, you really want the jury to know things, and for whatever reason, a judge will say, no, you can't tell them about this, or you can't say it that way. And sometimes the rules of evidence get really, really frustrating. And there's always this tension between sometimes what the truth is and what the rules of evidence will permit juries to know. And that's a longer discussion than we can probably talk about.
Yeah, sure. Okay, Gray wants to know, how can you get count 5 without count 3, or vice versa? And the answer is there, you can't. Those who are confused, and you can read the counts if you go on courtchatter.com and click on Harris's big old face that pops up in the pictures in the header, you'll get to his page we have for him. And you can read the counts, you can read the actual indictment. I've also just laid out the counts for you there and tell you what goes with what. So for us lay people, count 2 is felony murder, but the underlying felony is cruelty to children that requires malice, okay? And that's count 4. Count 3,
different kind of malice.
Yeah, count 3 is also felony murder, but the underlying felony is count 5, which is also cruelty to children, but it's in the 2nd degree, and that requires criminal negligence. So there's these top 5 counts. 2 are felony murder. Count 1 is malice murder. Then we get into count 2 and 3 are both felony murder, but the felonies are cruelty to children in the 1st degree and cruelty to children in the 2nd degree. So that's how those match up. Do you have more to say about that?
Well, yeah, and I would like to point out that the jury could find him not guilty of counts 1, 2, and 3, but guilty of the rest.
That's what Gray's question is. How do you find him?
The reason they can do it is because they can. Okay, they do have the power. And now legally, it doesn't make sense. If you find that he's committed cruelty to children in either degree, then theoretically you should find him guilty of felony murder. But if you got somebody back there in the jury room that says, look, I know what happens in Georgia when people are convicted of murder. I know they get a life sentence. I know they get life without parole. And I don't think this guy deserves life without parole. So what we're going to do is we're just going to find him guilty of cruelty to children in the 2nd degree and everything else, and be done with it. And if they put not guilty on any count for whatever reason, it's called jury nullification. Essentially, they have the power to do that, and it's perfectly legal. There's nothing anybody can do about it if that's what happens. The state would be stuck with that verdict. Now, it theoretically could happen. Neither side is allowed to argue for that to occur. You can't ask the jury outright to nullify something, but it happens. So theoretically, if they find any cruelty, they should find a felony murder. But it's the jury. It's in their prerogative to write not guilty on any or all those counts. If they don't like the police department, and they think the cops just had a vendetta, and they know he's been in jail for 2 years. How they would know, I don't know. But they could just say, you know what, I don't like the police. I don't like the prosecutors, and we're just going to find him not guilty on everything, even though we know he's guilty. They can do that too.
Yeah, and that is called jury nullification, and it does happen. I don't know that it's common, but it does happen that jurors.
I wouldn't count on it in this case.
Yeah, jurors kind of go rogue and want to do their own thing. But Boring did say in his closing argument to them that they are not allowed to consider punishment, and jurors are not allowed to consider punishment when they are deciding the guilt phase, and that they are to report it if there's any discussion in there about punishment. So that I found that very. We don't always.
I've never heard a prosecutor do that, and again, I've tried cases with Chuck Boring. I've never heard the prosecutor do it. I have heard defense lawyers try to inject punishment into their argument, and judges will always instruct jurors that, at least in Georgia, they're not to concern themselves with punishment. But I remember, and I'll just tell a brief war story. I was defending an armed robbery case where my client was absolutely innocent, had a rock solid alibi, and I could prove it. And I said to the jury, I said, Georgia's criminal justice system has more innocent people in it than you would feel comfortable knowing about and being able to sleep at night, and drew an objection from the prosecutor stating that I was injecting punishment into the trial. The judge's response was, Mr. Prosecutor, this jury's not stupid. They know what happens to people who commit armed robbery in Georgia. And so the judge actually, kind of got it out there, and the jury acquitted because they said they didn't want this guy to go to prison. So a lot of times it's the defense that wants jurors to know about mandatory minimum prison sentences.
Right.
Because they might vote a different way if they knew that somebody was facing a really severe outcome.
Right. Okay. CM Fountain has a question about the alternates. Are the alternates present during deliberations? And the answer to that is no. The alternates do not deliberate with the 12, but sometimes they're kept actually at the courthouse in another room in case they're needed. A lot of the times they're sent back home with the charge that you are still not to speak about this case because you could be needed at any time. Do you know how the alternates are going to be handled in this courtroom?
All I can tell you is what I've known Judge Staley to do in the past, and I've had a lot of trials with her. She will tell them before they deliberate tomorrow, she will announce, if she didn't do it today, and I don't think she did.
She announced the alternates today.
She did?
Yes. At the end.
Okay. Well, what she will do is once the people find out they're alternates, they're like, oh, you got to be kidding me. I don't count. And I had to sit here for this whole time. What she's done in the past in cases that I've been involved with is, and these were not cases that lasted this long, she would basically find another place for them. It's usually just one or two to sort of hang out and do what they need to do and segregate them from the lawyers and also from the rest of the jury. And if you lose a juror for whatever reason and you bring in your next alternate, you're going to bring in the one who's next in rotation. It'd be the next one selected in order. You bring that person in, and they would be instructed to begin their deliberations all over again. So you can't just pick up where you left off with a new once an alternate becomes on an actual juror. But if she does what she's done in the past, she'll find another room for them to hang out in. Whether she lets them go home, that's in her discretion to do it. This is an unusual trial. It's possible that she will do so if they can be reached on short notice.
Okay, we talked about Dr. Diamond a little bit in our last show, and he was supposed to be a defense expert witness, and everyone, including you and I, expected to hear from him, and we didn't. So Allie wants to know, does Phil know why Dr. Diamond did not testify?
I don't know. I don't know for sure. I have my suspicions, but I don't know. My suspicions are that after the memory expert testified, it was my recollection that Boring did a decent job cross-examining him and got him to make certain concessions, many of which he very clearly pointed out to the jury today during closing arguments. It's possible, and it may even be probable, that some of the testimony that came out on cross-examination or maybe even on direct might have conflicted with what the defense expected Diamond to say. And so the last thing that they would want to do is to bring two experts on essentially the same subject matter that don't agree with one another. So I think that decisions are made during trial, and these decisions are based on how the evidence unfolds at the time, and they're matters of strategy. And I think the plan was for Diamond to testify. Obviously, he didn't get called, so there was a strategic reason for it. The decision apparently occurred, and I could be wrong, but it apparently occurred after the cross-examination of the first expert. My best guess is that they were concerned that there might be some conflicts between what was testified to by one expert and what might be testified to by Diamond. That's just my best guess. We'll have to wait and see.
That's interesting because that other expert was the memory failure expert, and people think he got torn up on cross, or at least that a good job was done on cross-examination. So maybe what all came out and all that, they decided that we're done. There's enough reasonable doubt right now, and we're just going to walk away while we believe we're ahead. Whether that's true or not, nobody knows.
Well, it's just like, to use a football analogy, sometimes you start out with a game plan, and sometimes you have to change your game plan during the middle of the game. And sometimes you got to, your football team's on a great drive, but then you get sacked and you got to drop back and punt. And maybe that's the best analogy. I don't know. I certainly, these people don't share trial strategy with me. I'm just doing the best I can to read the tea leaves based on what I see.
I'm going to put you on the spot right now because you don't know that I'm going to ask you this question. But everybody in this case, except for the defendant. We have a chatter in our chat room that's been with us for a long time, quite some time. And she is Ross Harris's cousin. And she kind of, I don't know if that's a second cousin or what. I think his grandma is her great-grandma, okay? But they grew up together. Her and Ross grew up together. And she has been in our chat room throughout this trial. We all really enjoy her a lot because she doesn't get offended one way or the other, and she'll discuss this case. But she said the family was told by Kilgore not to come to closings, that he didn't want any extra outburst or anything to distract from that, and that's why that side was empty. What do you say about that?
I will say that I understand it. I would, they haven't been there for the trial. There hasn't been any family support for Mr. Harris during the trial. And strategically, it can help. It might make a jury kind of feel some sympathy for somebody if they feel like they're just out there on their own. They got nobody in their corner, and they got the awesome power of the state bearing down on them with all their might. If a family member, let's just say a grandparent, I don't even know if there are living grandparents of Cooper. I guess there is. We heard from one. So one grandmother testified. But so
both Ross's parents are alive.
So maybe their presence. First off, the jury might not necessarily know who they were, right? So, but the press would, and it might create a certain disruptive atmosphere given the high-profile nature of this case. That might have been why Mr. Kilgore just kind of wanted the jury to focus on what he was saying, not who was sitting in the courtroom. That's a guess. That's just a guess.
It's interesting that you say an empty side of his courtroom could maybe lend his sympathy from the jurors, and many see that the opposite, as in nobody's supporting him. They all believe he's guilty. So I think probably.
Who likes him? Regardless of whether or not he intentionally committed murder, nobody really likes him because of what we have learned about him. People think he's a terrible person. And so I think that the defense had to own that from the very beginning. They talked about all the shame that he's earned for himself. So maybe they wanted the jury to see a person who was at the very bottom of their life. Somebody who was an admitted sinner, a prolific sinner, but someone who nevertheless loved their son and was devastated by his accidental death. And now you've got lying police officers and the entire apparatus of the state government coming down to bear on him. Maybe that was the image that they wanted to portray. I don't know. I'm just sort of batting around hypotheticals that might be the case. But there could be any number of strategic reasons why he might make that determination.
Okay, thank you. All right, it's been an hour, so I think we're going to wrap this up. As always, I'm going to end with Phil giving his comments. But first, I'm going to give my comments. It's all over, folks. It's done. We've seen all the evidence. We've heard the closing arguments. We've heard all the testimony, and this is it. So you really have to have your mind made up now, or do you? Here's what my thoughts are. My thoughts are they're not going to find him guilty on the 2 counts that involve malice or basically intent. He intentionally killed him, and that's counts 1 and 2. I don't believe he's going to be found guilty on that. However, I think it could be a hung jury on both those counts because I think there's going to be a lot of talk going on in that jury room about intent. And what I like to judge juries on is what I see during a trial from our trial watchers. And they are all over the place on this. And we put a poll up, and on the poll on Twitter so far has him guilty of intent, but there's enough that have him not guilty that still leads me to believe that I think it's going to be a hung jury on though. I don't know that he's going to get it outright not guilty. I just don't think he's going to be found guilty. Criminal negligence. Oh, go ahead.
If you, I don't mean to interrupt, but I'm
going to let you take us out with all your thoughts on this. Okay.
Well, first off, I think, and I said this on Facebook or something the other day, I think that all of the lawyers in this case did a very, very good job under really bad circumstances. I mean, so far away from their families, their law practices, their offices, their own children, their own lives. Everything's been on hold, including the judge. These are all people that have uprooted themselves and been displaced quite a ways away from their local community. And they've all done a very good job under very or less than ideal circumstances. And so I think we've seen some excellent lawyering, and this is I hate to go back to football. It's like a Super Bowl or this year's World Series. We really saw a really good fight, and we didn't really know until it was over how it was going to end. And that's sort of where we are right here. If I had to make a prediction, and I hate predicting jury verdicts, okay, I'm going to predict a conviction on all the sexting charges. That's the easy part. Okay, I'm going to predict that he will not be acquitted of murder. Okay, there's either going to be a hung jury on all of the murder charges, or there will be a conviction on at least one of them. And I would not be surprised if he's not convicted of all of the murder charges, including malice murder. And the reason I say that is because the prosecution did a thorough job of causing him to be somebody that is despisable or despicable, I guess is the right word. And so there's going to be some bleed over effect from that. Now, whether that's right or wrong or should have been done or shouldn't have been done, other people can debate that. But I think that there's a decent chance he will be convicted of malice murder. I think that if not malice, I think he will be convicted of felony murder based on criminal negligence. But I wouldn't be surprised if we don't see a malice murder conviction. They're going to have in their jury room things that we did not see in the trial, because lots of items of evidence were simply introduced, admitted into evidence, and witnesses would talk about bits and pieces of them, but they would not read all of the text. We didn't get to hear or see the text message exchanges where apparently Ross Harris was telling a 15-year-old how to perform oral sex. We didn't get to see the actual photographs that the jury saw. We didn't get to see some of what I suspect might be very, very damning evidence that the jury will have in their jury room, thousands of items of evidence.
Which is why we kept a long, correct?
Say that last part again.
It's why we longer duration.
Yeah, so it's going to take a long time to get all the evidence together and line it up, and it's going to be a long deliberation because there's so much to read through and so much to look at. And I think that it's entirely possible, if not likely, that once a jury goes through all of that, they just said, yeah, you know what? There's just no way this wasn't intentional. So, and I'm not advocating a position. I don't know if he's guilty. I really don't. I don't know what the jury's going to see in their jury room, and I don't know how they're going to take it. A lot of people make very reasonable arguments against his guilt, including his own defense team made some excellent arguments against guilt. But reading tea leaves, if I had to make a prediction, I would say he's going to be found guilty of at least some murder charge. Mr. Boring said in an opening statement it's really going to be about malice, and that may turn out to be the case. Maybe they get hung up or acquit him on malice, and he's guilty only on count 3. Either way, that's the life sentence.
Okay, well, I think you and I will try and do another show post-verdict and talk about everything that went down and how long the deliberations were. Thank you again so much, Phil. Please follow Phil on Twitter at Phil Holloway ESQ. Find him on Facebook and like his page. And as always, we are grateful for everyone that was in the chat room asking questions. You can see this later in the archives, and we'll see you next time.